Hello, everybody. Welcome back to the Craig Henry channel. Today, we are doing an emergency live stream. We have got the court date for Chile Decastro. That is Delete Laws on YouTube. It is going to be live. We've kind of been listening to the pre-game chat here. We've got a kind of we have got the 8th Judicial District Court Department 12 being live streamed, and we've got kind of a pre-game setup going on their live stream. It's the our Nevada judges live stream. And so I am going to share that with you. And every now and again, we're going to comment on it. We're going to make sure that you guys can see that properly. Okay. Brilliant. Now, I want to give everybody some background. These guys, they're like statists, they're massive statists. They're basically doing everything they can to justify what the police, what the prosecutor, what the courts have done to Mr. Decastro. Now, I take the opposite view. I don't think that what the states, what the courts, what the police did to Mr. Decastro was right. So I take the opposite view, but we're going to get into this video. We're going to show you what they're talking about here. We're going to go to the live.
It goes because she is taking away the officer's focus, right? The officer speak her mind.
Which brings up an interesting question in this case, right? Because Decastro claims he's doing a public service,
And then he definitely believes that,
and then he's a member of the press.
Correct, right? He is legally.
He?
Oh, absolutely.
Okay.
Yeah,
100%. Without a doubt.
I agree with you. Explain why.
Well, because the whole freedom of the press does not. It's clear under case law that the freedom of press is not just Fox 5. It's every person who's trying to gather information or give information about public affairs, about things that are public interest.
Correct. And that's something that's very, very important.
And I watched some commentary.
Brilliant.
On the case. Somebody was complaining he was claiming to be a member of the press. Well, that's ridiculous. But the fact of the matter is, he has 500,000 followers. 500,000. That's more than circulation of the RJ, I guarantee.
Yeah.
Sure.
More than circulation of a lot of papers.
Yes.
And so there has to be an outlet, I suppose, for those sorts of activities too, even if they're not Walter Cronkite,
And that's
Eduardo Murrow.
I think my issue is with the use of the word press, because I think he is a sharer of information. I don't think that press to me implies that it is
real, like traditional. Like
I mean, I would call him a vlogger. I would call him.
That's the press, though. You can give him that.
So, and just so everybody, I think I've got myself. So yeah, no, I don't have. So just so everybody knows, this lady, Lisa Sizik, or I don't know, it's some weird name. She's a defense attorney. These are the people that most people are hiring to defend them against the state, and they continuously and constantly take the state's viewpoint on almost every single subject. So just thought I'd point that out, but we'll go on.
Yeah, absolutely. I mean,
you're not taking the position that the press is necessarily objective now, because I think we've seen a move away from that.
No,
from
I'm
both
not.
sides.
But I don't. Again, I have.
He's not super legit.
Yes.
Right.
Yes. Like he's not. I would not. Like he's not getting a press pass to go into a news conference.
No.
And what would stop anybody from any private citizen to pull out their phone and say, I'm a member of the press, right?
I think there needs to be a distinction there. Although I don't disagree with you that he has some legitimacy with his 500,000 followers, but I don't know that I could go so far as to call him a member of the press.
Well, he's certainly
Not traditional press. I agree.
He's certainly self-aggrandizing. Right?
Sure.
Yeah.
Yes.
He certainly pats himself on the back every chance he gets.
He definitely does that, both hands.
And certainly is in the face of authority. But
Sure.
the flip side is, we don't have people that are willing to do that. We don't see the video on George Floyd.
Yeah.
We don't see Rodney King 25
No,
years ago.
He's
They're all
performing a service. I do agree with that.
And it falls under the
And
First
he
Amendment.
has a large. I do agree with that.
Yep.
And he has a large audience, so I can agree with all of those things. My issue is just
He can go into the White House.
Yeah.
He can be part of the press corps. I agree with that.
Yeah.
But the flip side of this, though, if setting aside the taping portion and everything else, what does this case say about how to handle yourself or not handle yourself in a courtroom, for example?
Right. Okay.
That's a funny one.
So Interestingly, I think that actually raises a completely different issue because so judges.
You notice how the mood completely changed because instead of now commenting on this guy Chile, who, all of their bosses, all the judges, all of their peers, they really just don't like Chile. But now they've got to comment on the judge's behavior. And so the mood completely changes and they're all very hesitant to speak. It's pretty funny. Let's see what they say.
Set the tone for what is appropriate courtroom decorum, right? And we've seen it in many courtrooms besides just Judge Zimmerman's. I myself have seen my own clients be taken away by multiple marshals in which I've had to put my hands up and step away from the table because they have not liked the sentence that has been rendered on them. I have also seen my clients slam on the table and scream obscenities in the middle of trial because witnesses have said testimony that was not true. Client control is real for defense attorneys. I don't have to tell you that. But I think what he did here was just part of the persona that he portrays. Whether he believes it or not, or it is a persona, I don't know. But whatever those were antics. And perhaps for clicks and views and clickbait, it did not help his position in any way.
Well, it certainly got him more punishment.
Sure.
Right.
Yeah.
But it also drove people
it
to, I've seen the trial views.
That's an interesting take that the chief deputy public defender there, Scott Coffey, says that, it wasn't his actions that he was charged with a crime for that got him sentenced to more time. It was actually his actions in the courtroom. So it really shows that, breaking the law is one thing, but you disrespect a judge. Well, that's a whole nother thing. And the chief public defender there, the chief deputy public defender, he acknowledges that. And that's a refreshing thing.
Something like 500,000 trial views.
Again,
crazy. So the punishment, he got 6 months.
Max.
She was, in my opinion, Zimmerman punished him for his behavior in the courtroom, not for his citation. Because how many times have you defended an obstruction citation and it has been 30-day suspended sentence, go take an impulse control?
Well, one of the most interesting things to me about this whole trial was Agnes Botello, the prosecutor, asked for a $500 fine and a suspended sentence.
Yeah.
Sure.
But when's the last time you've had a prosecutor come in and ask for a fine, nonviolent offense, and the judge says, you know what, I think I'm going to give you 6 months in custody? That is a rarity, I would imagine. In my 30-year career, I've never had it.
I've seen it happen once. And again, in that moment, that was when my client slammed on the table and started screaming obscenities, where the judge went sideways on my sentence.
Mm-hmm.
Yeah.
But again, my client had behavior that was similar to Decastro's in the courtroom.
But judges also have other tools to deal with that, right? Contempt of court.
Sure.
But contempt of court's only 25 days.
Yes.
So,
and contempt of court is a little bit, you have to consider it has to be a violation of a lawful order. And did she tell him to stop? Did he commit? And because there are two things to consider with contempt of court. One, the egregious behavior has to happen in front of the judge, which in this case it did. And two, there has to be an order. So did she order him to stop and then he did it again? Or did he just have an outburst and she got tired of it?
For the viewers, should we actually say what the egregious behavior is? Because I think it's important for our viewers to understand what we're referring to. And I'll say it, he basically, the judge said that no phones were allowed to record. There's only one organization allowed to record. I think it was our Nevada judges.
Yes.
What?
And they properly filed a media request.
And so he did not, but she's not stupid.
She was concerned about officer safety. Do you think that's honestly it?
For the sentence?
That's a tough question. I know what she said on the record.
Sure.
Okay. But I got a pretty good feeling what he's being punished for. And it's not for violating officer safety.
The question is this. I think the question is this. If you had a guy who was within 10 to 15.
That is an incredible statement from that public defender. This is my favorite public defender. He goes, I'm pretty sure I know what he got sentenced for, and I don't think it was because of officer safety. And, we know what he got sentenced for. He got sentenced because the judge doesn't like him, because the state of Nevada, because probably the government in any state that he goes to just won't like him. It's kind of sickening, to be completely honest. Let me know what you think in the live chat.
15 feet, because I think he backed up a little bit. If you had a person 10 to 15 feet simply doing this and got arrested for obstruction, would he get 6 months in prison? I'm sorry, jail. Probably not. No.
But also, if you had a guy 10 to 15 feet and he was simply doing this, does he even get the citation?
Does he even get contacted? I don't know. I think that I told you the aggression is going to be part of the calculus, right, for the officer, and I think that's fair.
And I think if you have the guy who's 10 feet out and follows the command the first time where the officer says back up and all he does is still stand there and do this, we never have this case. We never have this conversation. And you have a guy who doesn't have 500,000 YouTube viewers, right?
No.
Because this is boring and this doesn't get clicks.
Anthony, you've done training for
Everybody.
decades.
Yeah, a couple decades. Yeah.
Long time.
Yep.
I would imagine the training on how to handle these First Amendment auditors, these sort of things, has changed over the last 20 years.
Not only has the training changed, actually the training it used to be non-existent. It's the officer's mentality has changed. I will tell you that, if you look back 20 years, officers were falling for these First Amendment auditor audits left and right. They were basically being, they're just falling for, literally falling for it because it's a trap. A lot of these guys like Decastro, they want to see these officers lose their cool
And engage.
And then when I see officers and I'm not saying here wasn't right. I'm just saying in general, when you do see officers that don't bite the bait, you don't get any views, or you don't see the video at all. But we do see since about 20 years ago from today, you do see less and less officers actually engage in these people because they actually know that they're being played. Right. That's really.
But that also rises to the level of going back to your hypothetical just a second ago. You have the guy 10 feet, 15 feet. He's standing there. And again, he's screaming the things at the officer, but he's not in any other way obstructing, or he's even 15 or 20 feet back and he's standing there and still yelling the obscenities. Again, being anti-police is not a crime. Saying things that might hurt your feelings is not a crime. If he's not willfully or intentionally interfering with the officer in the engagement of his lawful duties, we haven't committed a crime.
But I will tell you what I tell my clients time and time again. They will complain about the officer was rough with me or whatever might happen. He doesn't have a right to do this or he doesn't have a right to do that. And I say, next time you get in a beef, you take a copy of the Constitution and you hold it up and you see how well that stops a baton or a boot to your head.
Yeah.
I think that I might try to get this Mr. Scott Coffey on for an interview because everything he's saying, we all know. Yeah, the Constitution is supposed to protect us. But of course, it's only a piece of paper. If you try to hold it up as a shield, it's what he's saying. It's going to fail. I mean, the police officer is going to do what he wants, regardless of what that Constitution says. And he's completely on point. That is exactly what happened to Mr. Decastro, to Chile Decastro in this particular case. And I'm hoping to see this come up very, very shortly, but let's keep on listening. It seems to me that we've got Mr. Scott Coffey here. He is looks like he's kind of standing up for the people's side of things. And then we've got these other two, Anthony Bandiero and then Miss Lisa. I don't know how to pronounce her last name, but and they're kind of looking like they're taking the state's side. So let's continue on.
Still hurts when you get hit.
It still hurts when you get hit. And the fact of the matter is, if you are antagonistic, you increase the chances of getting confronted, getting arrested, getting injured exponentially.
And they're human beings. I mean, just like Judge Zimmerman's a human being. If his behavior contributes to his sentence, it is what it is. It's part of being a human being, right? And people do have reactions to this thing. The one thing I'd like to address though is Decastro was not just filming and being antagonistic. He was also engaging the driver. Does that play any role for you in the officer's contact with him?
I mean, yes, because at that point it adds a level of maybe then he's rising to a level of interfering.
Right.
But did it stop the officer?
Right.
Because was the officer still able to write his citation? Did the officer even write the citation, or did the motorist just drive away? Because to me, if I stand there and yell, and unless what Decastro was yelling was, you don't have to answer his questions, you don't have to show your registration.
You can drive away.
Yes, unless Decastro was saying any of those things, which is bad legal advice, he's not obstructing.
Wait.
I mean, you don't need to answer that. You can tell somebody. You don't need to answer their questions. You can tell a person that. I mean, I don't know what this lady's talking about. Well, let's see what Coffey thinks about it.
Well, the bad legal advice is a whole different issue for this particular person, right? Because he says one of the ways that he makes money is selling legal documents online. Right. You have to wonder the value of those documents.
The unauthorized practice of law?
Yeah, I probably wouldn't buy those documents. But
sure.
Yeah. But there's a market for it, right?
Oh,
that's why he has that many.
Well, your sovereign citizen client had a license probably sold by Decastro.
Yeah.
It was 15 pages.
All right, everybody. Looks like the case is about to call. By the way, that sovereign citizen comment from that lady was from that gentleman was ridiculous, wasn't it?
Okay,
The only sovereign citizens are the
Deborah Jean
judges.
Stroh, C376548. We have it. Okay, good morning.
Good morning.
We got a copy of the proceedings, and we have a copy for you, so I'm just gonna ask them.
Were you able to get the tape?
Are these two different ones? Okay, they're two.
Good afternoon, everybody. My name is Scott Coffey. We are here.
Tell you that, if you look back 20 years,
Uh-huh.
officers were falling for these First Amendment auditor audits left and right. They were basically being, they're just falling for, literally falling for it because it's a trap.
In there.
A lot of these guys like Decastro, they want to see these officers lose their cool
And engage.
And then when I see officers and I'm not saying here wasn't right. I'm just saying in general, when you do see officers that don't bite the bait, you don't get any views, or you don't see the video at all. But we do see, since about 20 years ago from today, you do see less and less officers actually engaging these people because they actually know that they're being played, right? That's really.
But that also rises to the level of going back to your
Yeah, for a second there, I was kind of concerned that maybe we had missed the live stream, but no, we didn't miss the live stream. They just, I guess, accidentally cut to the courtroom feed when Chile was not about to be called. I don't know what the deal is, but I'm really looking forward to it. Let me know in the comments what you think is going to happen. I want predictions. I want one, if you think this case is going to be overturned, if you think Chile Decastro is going to walk out of there today, and I want two, if you think the courts are going to uphold this conviction in a massive usurpation of power, that even if you stand in the vicinity of a police officer, you can be arrested and thrown in a cage for 6 months of your life. All right, so please let me know in the comments below. One, if you think he's going to win. One, if you think Chile's going to win. Two, if you think the state is going to take the victory for themselves through their state-owned judges. Let me know.
Yeah, and is selling legal documents online.
It was 15 pages of the Constitution.
Yeah.
From Pennsylvania.
I look at it from the officer's point of view, though, right? There's something we said about the officer's in his squad car. He's looking this driver up, and he sees a random person engaging his driver, receiving end of a Decastro. Wouldn't you want the officer to push this guy back a little bit?
Yes, but for safety reasons of myself. I don't want some random stranger standing at my window. But also, as a criminal defense attorney, my window is only rolled down this much because you don't need to hear anything more than my eyeballs.
But you change the fact, change the answer. What happened with
you're not wrong.
Right? That's true. In this case with the female driver that was here, she rolled down her window completely. She was Decastro only 5 feet or so away from her, maybe 10. So, right, there's something to be said about that, where the officer can say, hey, maybe it's not just my safety or my investigation, but it's also her. And he actually did say in court that she had a right to privacy. Now, of course, we need to be careful with that, right?
Sure.
But I know what he means. Obviously he's not a lawyer, but what he means is, hey, I got to protect. He did say something like this. I'm responsible for her, and he is.
Well, he's essentially saying what Castro said in the other stop, which is mind your business, right?
Mm.
He got directly in the officer's face, mind your business.
Right, exactly. But it is his business.
It is his business.
Well, and I'll tell you, I think that the guy just made the claim that the girl is his responsibility, that her safety is his responsibility. Maybe he wants to take that on at a personal level, but on a professional level, we know that officers don't have a responsibility to our safety, to keep us safe. So that senior legal instructor is wrong. And I think we all know that, and it's verifiable too. I think I'll find the case while we're watching it.
That's his detainee. She is seized because of the officer's action, so he's responsible for her.
But she wasn't under arrest, so she's not a detainee.
Well, you know what I mean. She's detained. She's seized under the 14th
She's
Amendment.
stopped.
Yeah, she's not in custody. But the point is that he is still responsible in many ways for her safety and so forth. Now, I'm not saying.
But there was nothing there at that point that gave rise to the level of that was a threat. Decastro with his phone in his hand isn't rising any alarms that there's an imminent threat.
Other than generically, everybody is to some extent, right? And I would imagine as an officer, you are trained to some extent to say the worst threats are the ones that you don't see.
Yeah, and I do want to be careful though, because.
And by the way, here I think that the Miss Lisa here on the left actually made this point, but I found the case. So in 1981, case Warren versus District of Columbia, the D.C. Court of Appeals held that the police have a general public duty but that, quote, no specific legal duty exists unless there is a special relationship between an officer and an individual, such as a person in custody. So there you have it. I mean, they don't have a responsibility to take care of us or to protect us unless we are actually in their custody. And even then, when they don't take care of us and we're in their custody, the worst that happens is they take taxpayers' money and pay it to the families, or pay it to the person who was injured. We're going to get back into this video.
If we go down that road, then we have everybody's a threat. You're a threat right now, and
He is. Pushes back. How much of this is attributable to training? What are officers trained as far as being assertive, that sort of thing?
Well, look, I mean, the DNA of an officer is to be in command, right? I mean, that's from day one in the academy. They are taught to take control of things, and that's what you want. You think about October 1st and everything below that. I mean, you can't have an officer who's not assertive and in control. But the other thing is, of course, the part of training is don't forget the Constitution, right? I mean, it's not a recommendation; it's a mandate. And people have rights. So at the end of the day, make sure your orders are lawful. And that's what we're talking about here. It was the order to back up lawful. Did he back up enough? That's the question that I would love to see what the appellate court, finds, right? Because
I can be assertive without being an asshat.
Yeah, sure. I agree. That's what you're talking about.
Yeah.
And I think that's the difference there, because in the situation where he was under the police tape and the fatal, when death is involved, there is a level of respect, I think, that's required in any situation, right?
Mm-hmm.
And so, at least to me, as a human being, when someone has lost their life, there is a level of respect that I think the situation warrants, no matter the circumstances. And I think the experienced officer in that situation absolutely handled it correctly, in taking every step to de-escalate, minimize, but still I think he was also in command, just without having to raise his voice and show his muscle.
Metro officers are definitely highly trained in de-escalation. Could he have done a better job? I think everybody can do a better job, but overall, I mean, I didn't see something too egregious. He wasn't yelling at the guy. He wasn't threatening him. He was just saying, get back, you're obstructing and so forth.
How about the grab when he's walking to the car?
So, here's my thing. I think that my viewpoint has always been, even if the order was unlawful, even if he, per the law, looking in retrospect, he was back far enough. My view has always been that when officers, are going to put hands on you, you comply. And first of all, it makes sure that everybody survives the incident, right? Because, we know that when people resist, even if it's an unlawful arrest, people can get hurt. And usually it's not going to be the cops, right? Cops are the ones training, they have the bat belt, they have all the tools. So I think my viewpoint is him resisting and him pulling away, if that's what actually happened. Again, I wasn't there. The video is not super clear on how much resisting he did. I do not think that was, I think that's unlawful. That's what I think.
And the officer even said, I didn't think he was trying to
hurt me.
Right. Didn't think it wasn't that kind of situation.
Yeah. Just be non-compliant.
Just non-compliant.
Right.
Keep your hands off me. I'm following your orders.
Right.
And he appeared to be following orders at that point.
Generally, maybe not perfectly, but we'll see, right?
Yeah. No, it's.
And so what's interesting there too is, again, you have to look at the resisting statute, because legitimately, maybe not perfectly, is about as clear as mud. And so I think there you'll see a situation similar to maybe the Wilson situation, because I think we have an issue with how our obstruction and our resisting statutes are written, because they leave a lot of room for interpretation. And when you're actually trying those cases, it becomes a problem because it leaves a lot of room for interpretation.
I was a cop in Nevada, and I used to make a joke, like, obstruction was always the catch-all. Like, if you committed a murder and you weren't sure what type of murder, just end with obstruction. We'll figure it out later.
That's brilliant. He says he used to be a cop, and if you committed a murder, you just call it obstruction. We'll figure it out later. You can't make this stuff up. That's brilliant. I love that. And it's so true, but we'll keep going.
That Wilson case, that's one of the reasons I wanted to get on the show, because I really want to say, like, I would love to, for the judge, again, I'm not the judge, right? I'm not that smart. I don't know all the ins and outs of how this, you guys know way more about the criminal law than I do. I'm a civil rights focus. But I would love to look at Decastro in the lens of Wilson. Physical obstruction and fighting words. Clearly, it wasn't fighting words, right? But physical obstruction, they said it requires willful physical obstruction.
It depends on how sensitive you are as to whether or not it's fighting words. I mean,
Yeah,
I hate to say that,
but not, there's no way it's fighting words in Decastro.
No.
Right.
No,
We know that.
Yeah.
it should not be. But
Yeah.
But the point is, like they used to talk about victims in law school. You take your victim as you find them, right?
Yeah.
The eggshell victim.
Yeah.
And it's the same way with officers. You got to take your officers as you find them, and you might have somebody at a death scene, accident investigation, high stakes, who, come on, just get out of our way, mind your own business, go away, treat you very gently. Somebody else at a traffic stop who makes you the primary focus, right? I mean, different officers react in
and suspects
different
actions.
ways.
Yeah, everybody's human beings.
Yeah.
But we you know we do want an objective standard. So at the end of the day, I would love to know the court. I can't wait to read the opinion. Whoever's going to, whether it goes to Levitt or it goes beyond to the 3, right? Because the Court of Appeals. I would love to look at this case and say, was this physical obstruction? Because the thing is, what I care about is I'm not the expert, behind the scenes. I'm not in the court like you folks. What I care about is trying to give my officers guidance about, hey, this was a good case or this is a bad case because of it complied with the Wilson's interpretation of obstruction.
Yeah, and that's got to be hard to train for. I mean,
It is very hard.
Officers, nobody's going to minimize the job that officers have, particularly when confronted by even somebody with good intentions. And you can debate that, I think, with Decastro, right?
I definitely.
But part of its viewership.
Sure.
In all likelihood.
He has more. Hey, I only have 12,000 subs on my YouTube channel, so he's doing better than me.
I don't even have a YouTube channel, so
Right.
I just learned
But I'm a
about
member of the
doing
press.
this show.
Right. No, I think, and I will tell you this, since you brought it up. I know this officer. I've trained this officer who was in, the epicenter of this case. Really good officer, and I think we can agree that he has good faith. Like he wasn't, as far as he was just trying to do the right thing for his driver, for the violator. And well, now we're in court, and so far he won.
Well,
right.
So at both.
Goodness, people. Sorry, I didn't realize I was muted. So what I'm trying to say is that I think that was a really disingenuous evaluation of what happened. See, the officer sent the driver, the female driver, on her way. And then he started dealing with Chile as that's his main focus now. So as soon as, in my opinion, as soon as he sends that driver away, that's it. I mean, there's nothing to obstruct. There's nothing to interfere with. There's nothing to resist. So I don't know how this lawyer here can sit here and say that the officer acted in good faith when his traffic stop was over. If he didn't feel like it was that big of a deal that, he could just send the girl on her way, why not just get back in his car and drive away? So that's really my question. And I don't see how his analysis is genuine when it comes to that.
Scenes. One of the first things that the officers do to de-escalate, including the officer here, is that I don't care if you're filming.
Correct.
You film if you want it, which is, I will tell you, a sea change from when I was
huge.
When I was younger.
I would agree with that. I think we've come a long way because, again, what you were saying in that where they used to take the bait, the first thing they would put your phone down, turn that off, stop filming, and now
correct. Or him with wiretapping. In the East Coast, they would hit him with wiretapping violations.
Yeah.
Which is crazy. A felony.
Yeah, I mean that is just it is very different.
Yep.
There was a talk in the trial about the distance issue.
Yes.
And it's very interesting and very nebulous.
Yeah.
I believe because Decastro says 10 feet's what I've seen in these other cases, and that may well be the case.
Sure.
And the officer says at the academy, we're trained if you're within 21 feet, very specific number.
Yeah.
You're not going to have time to react if somebody rushes you.
Yeah.
Essentially.
Yes. So yes, that's the 21-foot rule has been around for decades, and it comes from the study about people if a person can basically get a knife and attack you within 20 feet. In other words, if they're within 21 feet or less, you're not going to be able to. Your reaction is going to be delayed versus their action. All right. So the problem though is, and look, the officer is at least giving a reason why he's telling to get back. That's great. The problem is, I think we all can agree, there is no 21-foot rule with the First Amendment. There's no 10-foot. And in fact, it could be 2 feet in a nightclub where people are filming and a cop is arresting somebody 2 feet away. You can't necessarily tell the person get back 21 feet because there is no 21 feet.
Yeah.
What it is, it's totality of circumstances. At least the officer had a reason. He's not an attorney like us, but there is no 21-foot rule when it comes to the First Amendment.
So one of the things Decastro does is he reaches for a second cell phone.
Mm-hmm.
And as I'm watching the video for that, I think, boy, he's lucky it's broad daylight
Yeah.
and has a reasonable officer and everything else, because when you're in an officer's face
That's a recipe for disaster.
and you start doing this with your hands,
I got you.
you are
Yeah, you're yeah. Mm-hmm.
you're asking for problems, and nobody wants to be in that situation. Nobody's saying that officers are, necessarily quick to react. Sometimes they are, obviously, but the point is, for somebody who's this constitutional law scholar that he claims to be, he seems to do a lot of things to create his own problems.
Well, he wants badges, money, and fame, and he's getting at least the fame.
Yeah, and money's an interesting one. We haven't talked about that because there's a civil suit.
Not anymore. To
Did
my
it get
knowledge.
dismissed and get summary judgment?
I think so. Yeah.
Yeah, but there had been at some
There
point.
had been. Yeah. One of many that that's his. Maybe that's part of his income, right? Not just with this agency, but around the country. He has the track history around the country. This is his job.
We don't know how many successful lawsuits Chile's given, but I do think it's an interesting thing to think about. The interesting thing is, why do lawsuits against the government get dismissed so often on motion to dismisses, which is what a motion for summary judgment is? That is to be interpreted as, or a motion to dismiss in a civil case, at least in Indiana, is it to be interpreted as a motion for summary judgment. But when it comes to suing the government, motions to dismiss get granted a hell of a lot more often in government courts than when the government is trying to press charges against an individual, and the individual files for a motion to dismiss the government's charges. They almost never get accepted. So it's an interesting double standard here. And this guy kind of brings it up like, oh, yeah, it was dismissed. And then he says that he makes money off of civil lawsuits all over the country. I'm not sure that Chile does. From what I understand, Chile makes money from his YouTube channel. He makes money from fundraisers, but he really gives all that money to other people. And then he makes money from selling his trifolds. And he's even donated money to me that he's gotten from his trifold sales, and he's donated that to me. So, yeah, I don't think that necessarily Chile is a successful litigator when it comes to civil court. I think he's working on it, but I don't think that's a part of his income.
Does anybody know how many 1983 claims he's filed? That'd be
Several,
interesting to find out.
but I am actually not aware of any successful ones. So his track record for being successful is, and I could be completely wrong, just with the hearsay.
Okay. Sure.
I don't think he's been very successful.
So at the risk of alienating a few members of our audience, who watches? Who are the 500,000 subscribers to this Deletes Laws channel?
Me? I mean, I'm not a subscriber. I don't want to give him that kind of homage, but the thing is, like, I do watch cops perform because it's a very stressful thing. And in order for me to be a trainer, I have to know what these cops are facing. And I got to tell you, I've done pretty good with first-amendment auditors in my job, but I've seen a lot of officers get baited with these guys because they know it buttons the push. When you're being told, there was one East Coast guy, he's really insulting about people's weight, about cops' weight, females, and so forth. Just a really atrocious stuff. I got to tell you, I got to prepare these cops like, you're going to go out there, and when you put that badge on, you are the paid professional. You cannot let these people get to you. And it's hard, but that's just the way it is.
Is this a training opportunity for you to some extent?
Always a training opportunity. Absolutely. I think there's a lot of good things in this video, and there's some questions. I already told you my questions. I want to hear how Wilson pans out with this case. But I think the officer overall did really good. He didn't lose his cool. I love how he told him, you can still film. Just look, you got to back up a little bit more. Yeah. And I think he did a good job on the stand. A really good job on the stand, quite frankly.
I think that there is a whole sect of people who are watching because we get all of our information from the internet now and less than legitimate sources. So what frightens me about the 500,000 people who are watching this is that they're looking at this as some kind of legitimate source of information.
Right.
Well, the thing is I mean, he can be a legitimate source of information. Now, sometimes he gets stuff wrong. I mean, a lot of the times he's just out telling coppers that they can't tell him what to do, and that is legitimate. So I don't know what this woman is on about. Now, I saw a question in the comments that I want to address because I'm sure there will be a lot of people that are wondering this. And the question is, why did Chile not get a jury trial? The reason Chile didn't get a jury trial is because in Nevada, apparently their state laws and their state constitution, I don't know how they get around this, but they don't require a person to have a jury trial in a criminal proceeding that's a misdemeanor. I believe it's only a felony that it's a requisite, which does not seem right to me. Does not seem right. And I'm not saying that I think it's right. It seems to me as though it's completely wrong, because what we have is we have a agent of the state making an allegation against Chile. We've got another agent of the state trying to prove that allegation in court. That agent would be the prosecutor. And then we've got another agent of the state that's going to decide whether the other two agents of the state are right or not. Well, I don't want to burst anybody's bubble, but when you've got three agents of the state and one private individual, and the one private individual is fighting two of the agents, and he's asking the other one to stick up for him, that other one isn't going to stick up for him. That other one is he's going to group up with the other two, and they're going to team up on the individual. And that's what's happened in this case. So, and that's why he didn't get a jury trial, because they're just not required to give him. So that being said, we'll get back into this live.
And that terrifies me.
I understand. Do we have any legitimate source of information anymore? I mean, that's it.
Our Nevada
That's
judge
it.
is the last one.
Right? No, but
Right? I want to. I mean, I get that we're allowed to.
All
do
right,
that in our
everybody.
Constitution,
Yeah, but you got
but
full for a
why?
Come on.
Yeah.
No, I'm just thinking for the entertainment
Oh,
value.
yeah.
yeah.
There would have been a lot of viewers.
We have got Chile's court date. It's coming up. I saw Chile on the camera. I mean, I hope it's getting ready to go, guys. So let's get into it. Come on, let's go. I hope that Chile gets totally exonerated of all crimes. I hope that he gets paid damages for what the government has done to him. Let's get into it.
He is present, he's in custody. The attorneys can state their appearances.
You are Chris Storm on behalf of Mr. Decastro.
Stand tall, big man. You got to stand tall.
But you can sit down if you want. You don't have to stand up throughout the whole hearing. It's up to you. Might be a minute.
Alexander Chen on behalf of the state of Nevada.
Mr. Orm, I'm assuming.
May I proceed, Your Honor?
Absolutely.
It seems that everybody agrees you have a right to film police officers. I'm not sure. I filed a lot of federal case laws suggesting you can film police officers, but the state doesn't seem to dispute that. In this case, you have a person who, for a living, this man for a living, that's his living. He films police officers. He has more than 500,000 subscribers. He is very, very famous as a First Amendment auditor. He is known as he testified around the United States and does this constantly. As I look at this case, there are multiple problems with it. It goes to trial, so let's start with what really happens. There's a letter written to the judge, and I cite to it, and you have a copy in the appendix. And the letter says this man's going to film the proceedings. So the judge says, empty your.
I'm hearing stuff I'm seeing comments in the chat that you guys can't hear the court audio. The court audio is low, even on my end. Just must be what they're picking up in that courtroom. That courtroom must just have some bad acoustics going on. So you need to turn your audio up. This is the best it's going to get. I've tried everything I can on my end to turn it up. This is the best it's going to get. Let's keep watching, everybody.
Your pockets, suit pockets, all sorts of pockets, empty them. He says why. He complains it's a Fourth Amendment violation. You don't have a right to take my phone. And the judge also demands that defense counsel turn your phone off. And she said, I don't want to be part of the YouTube chat. And he said, we already are. This is the starting point to this trial. And the state says, well, the court has a right to, keep the court secure. Absolutely, you do. Absolutely. have a right to determine who's filming, absolutely. But what was interesting in the state's argument is they forgot to mention that the court never looked at the prosecutor and says, hey, turn your phone off. Make sure your phone's off. It's all directed at him and his attorney. You can't take cell phones. You can't do that. It's structural error to do that. And it also kind of shows that the court had an animus towards Mr. Decastro, then judge. He makes a statement to the marshal. It's unacceptable. It's unacceptable. It's clearly unacceptable. The judge was agitated by it, understandably so. As I look at that, I'm like, I come in these courts all the time. You don't get to call a marshal what he gave. So I understand that's a different matter. He's not on trial for calling the marshal a name, which he shouldn't have called. Maybe you could hold contempt proceedings for that. There are remedies that a court like yourself can do if somebody's being disruptive. Just because somebody's disruptive in a murder calls your court staff a name, it's inappropriate. I would realize with a client, oh boy, this is not looking good. But that doesn't mean you're going to find or suggest that the person committed murder simply because he's acting or she's acting in a fashion in a courtroom that shouldn't have happened. But it was clear then that the trial was going the wrong way. So when we look at the facts of the case, that the police officer testifies that this auditor approaches, says that he's a member of the press, identifies him immediately as a member of the press. I have video here. I also have exhibits. And that he wouldn't back up. Now at trial, that was commented on by the officer a couple of times. He wouldn't back up. He wouldn't back up. The prosecutor argued it. Then they started on the 21-foot rule. It's an imaginary rule. We all know there's no such thing as a 21-foot rule. It doesn't exist. But nobody was stopping that. Not defense counsel was saying, where is this coming from? What rule are you coming up?
I'm so glad that this guy's pointing this out. This guy is making very valid points. Look, this 21-foot rule is just made up. Right? It's a creation of the police academy, but it's not an actual rule. So great point by the defense attorney.
Coming to with this. And the prosecutors argue, well, he's violating the 21-foot rule. There's no such thing as a 21-foot rule. And the state, to their credit, has abandoned and completely retreated from the 21-foot rule on this appeal. They don't argue.
Testify it was something he learned in the academy.
Yes. But I understand what it is, Judge, because I've used it myself in murder cases, and that is what they're argued that my clients are enduring is that if an assailant comes at an officer or a citizen within 21 feet, you won't be able to draw your weapon. That's what they're taught. So it's something that we use in a self-defense case. Oh, look, the guy was, coming, and so my guy had no choice but to shoot. I understand that's what police officers are taught, but that's got no bearing on this. There is no 21-foot rule, and in fact, we just go to Click. Click is a First Circuit case, both the state and myself rely upon it. And in Click, I thought the language was so important to this case, because in Click, they begin speaking about that officers, in that case, versus filming on the Boston Common, filming from 10 feet away. That's very relevant because the police officer in that case said, Mr. Decastro was 10 feet away. And so the First Circuit said that is 10 feet away. And then the First Circuit starts saying, police officers need to deal with provocative and challenging speech. They further identify that when a police officer comes in contact with somebody who's being rude or obnoxious, that they feel like they shouldn't be filmed, that they shouldn't have to endure that. And the First Circuit then goes on to talk about that officers sometimes retaliate because they don't like it. They don't like it. And they said that's what happened in Click. The officers didn't like it. You don't film us. You have no right to film us. Okay? And so when I look at the situation, I'm like, officers, we have a right to film officers. In fact, we have an actual statute on it. NRS 171.1233. This is cited in page 2 of my reply brief in footnote 1. Subsection 2, subsection A states, a peace officer shall not act to interfere with a person's recording of law enforcement activity, including, without limitation, by A, intentionally preventing or attempting to prevent the person from recording the law enforcement activity. You have a right to do it. We know it by statute. We know it by federal law. So what does Mr. Decastro do? When the officer tells him, back up, I can prove he does. I've attached the exhibits. I don't, if the state wants me to, I'll put it up and I'll show it, but we can see from Exhibit A that where Mr. Decastro is standing, he's standing in a particular parking space. We can see in Exhibit B, he has now moved back into the back parking space. I don't, when I say back parking space, I know that may be not a good record, but he's moving over.
Right, it looks like it's in a parking lot.
Yes, it's a parking lot. He's moving from one parking space away. You can see it's away from the officer. So the state, to continuously argue he would not back up. Why are they doing that? Because they want to say he won't follow the commands. And the accurate answer was, and I think the court would say, if you were asked to look at this case and say, what did Mr. Decastro do when he was told to back up? He backed up a short distance. That would be fair. Maybe the court would not like that language, say maybe it's a few feet. But he did back up. What is not fair is he would not back up. He would not comply. He did not back up. And then the officer was asked, did you tell him how far? No, because he was disrupted. So I couldn't tell him how far. The 21-foot rule. There is no 21-foot rule. Click said 10 feet was fine. And in Click, what's more interesting about it is the officers, what Click is deciding is not like this court deciding whether there's criminal activity. Click is suing the officers. And the officers are over in federal court saying, oh no, give us qualified immunity. And the federal court said, no, not for this. You're not getting, for arresting somebody who's filming, you're going to get sued. You're not getting qualified immunity. You're going to have to fight this and go to a jury. I think that's very relevant because that's what's going to happen with this officer. Undoubtedly, you know he's going to sue, and I think he's already started that process. I'm not a civil lawyer, so don't do that. But I know that that is what's taking place. So what is hindering this man from obstructing him from writing his ticket? He can just simply write the ticket. He can look at Mr. Decastro and think to himself, here's one of these auditors, walk over and write a ticket. He was asked the question, which I thought was really good at trial. He was asked, how did he obstruct you? How were you obstructed? And he said, well, I didn't know what his intentions were. I didn't know. Maybe he was armed. Well, that doesn't obstruct you. How does that obstruct you? That doesn't, he never gets in the way. So let's fast forward to Wilson. Okay? 3 weeks before this trial, the Court of Appeals considers one of my arguments here that the statute is unconstitutional, vague, and ambiguous. The Wilson court determines that the only way to impede, the only way that you impede is that you have fighting words or you physically do it. And the exact language of it is, we interpret 197.190 as applying only to physical conduct and fighting words. The court further explained that blocking the path of an officer may amount to obstruction. Well, that didn't happen. You can look at the video. There's no blocking. There's no blocking that goes on.
This is the reason why we know these cases are ridiculous. This guy is laying out in plain English every reason why this man, Chile Decastro, should not have been ascertained by state agents and thrown in a cage. Put a 1 in the chat if you think Chile's going to win with this brilliant argument that his attorney is making. Put a 2 in the chat if you think the judge is going to completely ignore every relevant point and rule in favor of the state.
And they also say that it could be non-aggressive, which made me curious. So I went and read the case. I thought, what could non-aggressive be? And it makes perfect sense. I would have never seen how non-aggressive could be obstruction. But what they then cite is they were pulling over an individual, police were. And then the guy who I guess is armed then starts to run from police. Well, now they've got to go chase him. So clearly you're hindering the police. So that made perfect sense. And that's the case they cited. What is interesting about Wilson is they also go on to say, as construed by this court, NRS 197-190 prohibits only physical conduct and fighting words that hinder, delay, or obstruct a public officer in the discharge of official duties or powers. As such, law enforcement has no discretion to arrest persons for protected speech or for physical conduct that is merely annoying and offensive. Judge, I have no doubt, I know you've watched this video, and I could see how anybody could look at this and hear the speech, get in your car, little doggy, and write your ticket, and find that
Sorry about this, guys. I don't know exactly what's going on with the video.
Annoying, I see that. But that's protected, and we've been told that's protected now by our courts in Nevada, by numerous federal courts. They went on to say the district court did not, so in Wilson was convicted, appealed, just like I'm doing here. And they point out in Wilson that on appeal, this court explained the district court did not have the benefit of our interpretation of 197, 190 as being limited to physical conduct or fighting words, and therefore did not consider whether there was sufficient evidence that Wilson engaged in physical conduct or other fighting words so as to support her conviction, and the case was remanded. Why I think that's important is because one of sort of the big picture that I want the court to see that I'm arguing, I think Judge Zimmerman was put in an absolutely terrible situation. Here's look at all this litigation we're doing here. This isn't new. I didn't come up with, oh, look, there's a new case.
I don't agree with that.
First Amendment issue. A lot of the cases I'm citing are, 20 years old, 15 years old. This is known law. If we have this issue before you on a case, isn't it incumbent upon me to file this pretrial?
I wonder why that didn't occur in this case.
And the state says something interesting, which I understand the state's advocating. The state says that trial counsel filed a memorandum. Well, I'm like, it was comical. I understand what the state's doing. They're saying they need to try to protect their conviction. But the trial counsel, what he did is he filed some memo that right when the judge is making her decision, finding him guilty, she's like, what memo? He said, well, I filed them. She didn't read, and then the state correctly, the state said, strike it. It's late. So what trial counsel does is, at the last minute, can you imagine I'm coming in here talking about the facts and all of a sudden I'm like, oh, Judge, there's a First Amendment issue. Like, well, don't you think you should have briefed that and let me know? And I hear the state's argument, and the state says courts are presumed to know law. And I know you know law, but I also know, Judge, that we get into issues. You've been on the bench a long time. I know you know the law. But let's say we're going to talk about a Miranda or Messiah issue, I think that it's incumbent upon us to give the material to the court. Let the state oppose it. Let us reply so the court can look at everything. Have the court's clerk go maybe find research that interests you on this so that you can make an informed decision, as opposed to at the very last minute in a factual trial, like, oh, by the way, there was a Messiah issue. I don't understand why he did that. This was the issue. This should have happened beforehand. This should have been litigated beforehand. The court, like yourself, just like we're doing here, we should give you the opportunity to go look at it, and maybe my rendition of it is not the way you want to go. It's the state's rendition. But the fact of the matter is, at least you had it, and Judge Zimmerman didn't. And that's ineffective because he should have showed the court these issues. And if he had, just like here, the Wilson case would have come up. I know it was brand new. It was only 3 weeks before the trial. But then the court could say to the state, hey, you've got to have physical conduct or fighting words. We can't just do this on the driver's safety. Because at one point, the judge ruled, because the prosecutor kept arguing, and the police officer testified, well, the driver had a right to privacy. Like, the driver doesn't have.
Drivers out in public. I don't know if
Right.
the driver had a right to privacy. When you're out in public,
You don't have a right to it. And here's another thing, Judge. The state then comes back in their response. Mr. Chen always does an excellent job, and he did here as well. And he cites a bunch of cases, every single case. It made me realize when I read it that they have real legal problems. They've got problems with the law. Because what I did is I read every single one of their cases, and what I found was, oh, this is not at all what these things stand for. In other words, in fairness, they were saying their time, place, manner restrictions. Yes, true, the cases did stand for that. But let's start with Philadelphia, Fields versus City of Philadelphia. Now, when I first saw the video, what came to mind, just jumped to my mind, was I looked at it.
For public safety, good to see you here, brother. This is not the original lawyer that was in his original trial. No.
Hey, wait a second. didn't those people in George Floyd, weren't they filming it with cell phone? Now, I hadn't really followed it that much, but I kind of thought about it and it ran through my mind. So I then started pulling up the exhibits that I put, and I looked at it and I said, well, boy, those people are closer. They're closer than Mr. Decastro. Another thing that came to mind is, although I didn't really follow that trial very much, I did remember the firefighter. She's an off-duty firefighter, and she came to court with her uniform on. It was devastating for those officers because she said, I tried to tell them, and then they started saying, if you were a real firefighter, you'd know not to get involved. And she said she started using profanity at the officers. And she, at one point, is within a foot of the officers. There's an Asian officer in the back of the vehicle. She comes very close to him. When I look at that,
So somebody's asking in the chat, is this the same judge? This is not the same judge. This is the appellate court of Nevada. The judge in the first trial was at the district court level. So,
well, how is she not in the same situation as him? She's admitting she's using foul language. And I remember her trial testimony where she was crying, and I think it was extraordinarily impactful. I want to talk about something for a second, Judge. Police have to deal with difficult people. I know that because I witnessed it in your courtroom. Right there, right back there, right by the door. And I seem to remember I was in a capital trial, came up from a break about 1 in the afternoon. And what I see is Officer Hawks having to deal with, I don't know if she's a homeless lady or what, sort of small Caucasian lady, but out of control. And I'm watching, almost nobody's in here. And she's saying horrendous things to Officer Hawks. He there comes back up because I know there was a female officer, and they're trying to talk to her. Your marshal showed incredible restraint. I know that because I watched her try to kick him in the groin. She tried to kick him, and I watched it happen. And I don't think she was arrested. At some point, they did everything they could to just get her out of here. She was so obnoxious and abusive to your marshal, yet the restraint shown was remarkable. I remember that because I addressed it with Officer Hawks. How did you do that? To me, it was amazing that a human being could practice that type of restraint, and that's what he did. And that's what this officer should have done. He was angry. When the state says to you, and when the officer said, I was concerned for officer safety. No, he wasn't. At the point when he says to him that annoying language that we call, and the federal courts have said it, provocative and challenging, get in your car, little doggy, and write a ticket. First of all, he's telling him to write the ticket. He's not instructing him. He's just, it's like a directive. Counsel, be quiet and sit down. Okay, that's a directive. But you're not instructing me from being quiet and sitting down. He's telling him to do it. And so I don't understand how the state can argue when I can see it for myself that the officer was concerned for officer safety. When he says that, when Mr. Decastro says it, you can see the officer just gets irritated beyond my God. You don't say that to me. He just comes at him. He doesn't pull a taser or anything like that. He's like, you're detained. And then he grabs him pretty hard. And he's trying to say, well, I'm a member of the press. I'm a member of the press. You can't do this to me. He tells him, call your supervisor. Don't do this to me. And he's like, he brings out 2 cell phones, so he's not armed, and you know what he is. And even the officer said he knew about First Amendment auditors, but didn't say that they shoot people, because he was asked that. He goes, I don't know if I said that. He was agitated. This wasn't about fear. This was about, truth be told, you can see it's obvious. This officer was agitated. And the federal courts talk about that. They talk about a lot of these officers who don't want to be filmed. And I want to go back to City versus Philadelphia, or Fields versus City of Philadelphia, because in the state's answering brief, they question, why would you be bringing up Floyd? Are you bringing that up? And I realized the state saw, why are you bringing it up? I saw it was directly relevant to filming police. So since they cited Fields versus City of Philadelphia, I went and read it. And it starts off, so what that is that's an individual who's got concerns about unions, and they're filming in Philadelphia. And the court starts off with very, very, very interesting language. This is the Third Circuit. The Third Circuit begins their analysis This is the start of the decision. In 1991, George Holliday recorded video of Los Angeles Police Department officers beating Rodney King. They continue to go on about that. I cite that on page 4 of my reply. This case involves retaliation. Individuals making recordings have also faced retaliation by officers, such as arrest on false criminal charges and even violence. And that's because they're recognizing this. The federal courts around the United States are recognizing that police sometimes don't show the restraint that Officer Hawks does. You know, if you're being filmed and you got some irritating person, sometimes when we walk out of these courts, we got press and like, what just happened? Did your client just get convicted? It's like, yes. Did your client just, you know, they want to sentence him to death? Yes. And you have to be calm. I can't just grab people and do it. You gotta suffer it. Suffer it. He didn't stop anything. He didn't grab the officer. He backed off from the officer. Yes, maybe annoying. Yes, maybe provocative, but it is not obstruction. It's not resisting. These are trumped up charges. And that's what the cases show. They can't show you a case. Not a single case could they rely on to show this is obstruction or resistance. Not once. And in fact, like I said, I think trial counsel should have presented it to the judge beforehand. Then the judge could make a correct decision without even a trial. I think if the court had seen it beforehand and not being so agitated by calling the marshal a name, that the court could have ruled that this is clearly protected First Amendment speech. Judge also, so I believe that I've argued that this is a First Amendment violation to convict him of it. It's also under the Wilson decision in the case of federal case law we decided it is clearly arbitrary and capricious. It's being applied incorrectly, and the court did not have the benefit of the Wilson decision because Wilson remanded it to tell the district court you need to look at this. That did not happen here, and so that's a problem. I argued judicial bias. The state claimed that there was no objection. Again, trial counsel didn't object when phones started being taken, didn't make any kind of formal objection. But in Echeverria and in Gurry was my case, it's murder of an FBI agent, there was no objection. It was well before my time, but I do it on post-conviction. I handled it on post-conviction. And it was that the trial judge had been, the FBI agent who'd been murdered, had actually investigated the trial judge. And so they found that that was an implicit bias, and so therefore there was reversal. The judge should have recused herself. She should have realized maybe I should hold this man in contempt, do contempt proceeding, and send this to somebody else. She didn't do that. But I also think it was incumbent upon defense counsel to do a better job and inform her of that. And that leads into my last argument of ineffective assistance of counsel. And I know that on appeal it's rarely considered. However, I cited case law that it's clear as day, and I think the court can already see why wasn't this brief? Why is this whole hearing not happening prior to the trial date? So that Mr. Chen or whoever, it was Miss Agnes Alexis, why did she argue this against trial counsel and let the court make a decision? Judge, under the circumstances, reverse is mandated. It just, in every different area, I think under the Wilson decision, I think under the Click decision, I think under every single decision. And so I just want to make sure, Judge, that I cover all of my points before I turn it over. And that is, they say Mr. Decastro was angry and hostile. No, this is what he does for a living. That's how he approaches them to see, can they handle it? I think in other videos, if the officer handles it well, like Officer Hawks, then he kind of calms down a bit. He did.
I'll object to that as facts that are not in evidence, speculation.
I'll withdraw that argument. And what other time, place, manner restriction? When to do this as an auditor, to do this?
Target parking lot, right?
Yeah, in daylight, broad daylight. When if it was a female officer, not that if it's a female officer on a lonely highway going up to Ely, and all of a sudden somebody's approaching at 3 a.m, I think that's a different story. That shows officers like, God, what's happening here? And it's fearful. He does it in the most common way. He comes up, I'm a member of the press, annoying, provocative, all of those things. He's protected. It is one of the most, it is something that is sacred to what our system of justice is. And one of the decisions I cited said, this is the difference between us and a free society, where we can go up and be obnoxious to police. Hey, I see what you're doing. I remember from the time I was in law school, I cite the case, but I wonder if you remember, Mr. Chen remembers it, where somebody comes up to an officer and calls him a dick, which I think is really, I remember as a law student, you shouldn't do that, that's bad. Right? But the reality is, I then learned from the Supreme Court, it may be bad, it may be obnoxious, if it's your child, you'd be like, what did you say? But it's protected, Judge, and he didn't
That's
do
right.
anything to violate or have those protections taken from him. I'd ask that you guys.
Thank you, Your Honor. First, I'd like to
All right, everybody. Hey, that was a great argument from Mr. Decastro's attorney. I mean, I know I couldn't have done any better, and I'm sure that a lot of other people in the chat feel the same way. So this is awesome. So I've seen a few questions. It looks like there are people wondering if this could be case law, and this could very well be case law, depending on if they publish it, as case law. There are some cases that go through the appellate court that specifically say this is not for use in that regard. But this could be used as a piece of case law for sure to decide other auditors' cases or even other cases that are completely irrelevant to auditors. So we're about to get into the state's response. Let's see how he goes. Now, guys, I want to warn you, it's going to be ridiculous. It's going to be based in hypotheticals, what ifs, what could have happened. Not a whole bunch of stuff is going to be based in reality. Let's get into it.
thank Mr. Oram. Considering that our response was called comical, I appreciate the nice words from him today. Regarding first and foremost with the ineffective assistance of counsel claim, even if counsel could have done it, we're still focusing on the prejudice problem. Ultimately, we're here, and this is the appellate court for this matter, so this court's going to make a matter of law decision. So I think ultimately everything regarding that issue gets resolved on a prejudice problem, whether or not Judge Zimmerman was apprised of the information that he wishes to put forth today. Now, with regard specifically to the First Amendment claim, Mr. Oram mentions that we cite to a number of cases, and the cases factually don't support our position, and I think we recognize that in our brief. There are cases where police officers have stopped individuals from filming encounters that they absolutely had a lawful right to do. This is why the court consistently talks about time, place, and manner restrictions. We don't doubt that that's the case, but to suggest that we didn't read those cases, I think is an unfair characterization, because what we're trying to focus on is whether the time, place, and manner restrictions were present in this case. Now, what I would argue, and what I think we argued in our brief, is cases like Glick are relevant to the extent that in that case, the individual clearly was not impeding, obstructing, or being a problem to police officers. The only thing that individual in Glick was doing was filming officers, and the officers were upset by it. That's a very different situation when we're talking about time, place, and manner in this case. Yes, it's in a public parking lot, but you have to realize that as the facts came out, that the officer was letting the individual film until he approached the driver. Now, I agree, privacy is not a thing necessarily in public, which is why we didn't argue it. However, there are other concerns for time, place, and manner regarding safety of everybody involved, including the fact that.
And I want to say, maybe he's not arguing that privacy doesn't exist in public, but in the district court level, they did. So, I mean, if the district court made a decision based on evidence that's completely irrelevant or faulty, then certainly the conviction's got to be overturned, in my opinion.
When the officer's writing a ticket, when the officer's communicating with this lady who's been pulled over, when that lady is sitting in her car and not free to move because she's subject of a traffic stop, that the scene needs to be secure. Now, I appreciate that the individual, Mr. Decastro, could have plenty of followers, and he might have followers. I didn't know of him before this date, and it doesn't appear that the officer did either. So ultimately, the officer is treating this individual as someone who's filming, but doesn't know what the ultimate motivations are. It could be to film, it could be to do something else, it could be to interfere with the driver, and I think that's what the evidence shows in this particular case. Not only did he approach the driver, the key part where the obstruction begins to occur is when the officer asks him to back away from the driver. He says, well, I'm a filmer. Great, you can film, but I need you to back up. And again, we're quibbling over how much the backup was, but I think
Clearly backed up.
Yeah, and this is another thing. I mean, he didn't say he wasn't going to back up. He just said, I'm going to film her. That's not a crime. I mean, everybody acknowledges that. So I digress. This is for the defense attorney to say. I'm just here to stream it. We'll get it.
he backed up a couple of feet. There's no question about that. But I think what the officer testified to was he wanted it a further distance based upon, in large part, how Mr. Decastro was operating. Now, if Mr. Decastro had backed up a number of feet and continued recording and wasn't saying and doing the things that he was doing, I think we'd have a very different situation. But the problem is,
Mr. Decastro's supposed to know that he has to back up further.
the officer instructed him in the video that to continue backing up, and rather than backing up further, he stood his ground and said, no, I'm relying upon a fictional 10 feet rule, which I don't think is a matter of law. I don't think the First Amendment says 10 feet is automatically permissible, because you can do a lot of things
There are courts that have held 10 feet is sufficient.
depending on what the situation is, all right?
I agree.
If I pull out a gun, is 10 feet still sufficient? We're an open carry state, for instance, so there are individuals who can carry guns. So if we were to say automatically that I'm 10 feet away, and that as a matter of law, that's sufficient, I think it's very different if the individual is doing certain things. If the individual has a grenade in their hand, that's why it's time, place, and manner specific. We're not advocating, I didn't advocate for a 21-foot rule, even though that's what the officer said he was trained to do, in that he wanted the individual to move back a certain amount.
But he never vocalized that.
He
He
didn't,
never verbalized, said, hey, I want you to move 20, 21 feet back, go back to this line, don't come across this line. There was none of that because it happened so fast. I mean, the officer testified it was within like 10 to 15 seconds.
yeah, it's all on the video as well, Your Honor, so I agree that he doesn't give a specific number. And even if he had given a specific number, it's not that that specific number is somehow constitutionally permissible or
agree.
not. But the point is the manner in which this individual, who's unknown to the officer, is interacting with that officer in that very manner is what the issue is for us. And based upon that, the officer can't continue to feel that he can do his job, the traffic stop, speaking with the individual, of doing any records checks that need to be done, of writing the actual ticket, while this individual is yelling, refusing to move back at a further distance, and again, with unknown motivations. In hindsight, we can look at him and perhaps say, well, he was only here to put this on his YouTube channel. But ultimately, at the time that it's happening, this officer who interacts with him, who even tells him, you're allowed to film, but I need you to continue backing up, I think that's what the reasonableness is. That's what the time, place, and manner restriction is, not some magical number. As we point out in our brief, I think what Mr. Decastro believes and what counsel believes is that because Blake said 10 feet, that there's this line of 10 feet, and no matter what, I can do whatever I want within 10 feet. And I think even Wilson, although I understand it's remanded for further hearings, goes against that proposition that, oh, there's some type of magical number or anything like that. This individual in Wilson is yelling as there's a suicidal individual who obviously a delicate situation. The police don't want this individual to hurt himself, and Wilson continues to yell and interfere with what's going on. Specifically in Wilson too, that even though they say physical conduct again is made up of multiple different things, including what we do with our bodies, but as well as what we're saying and how we're acting throughout the course of the interaction. And Wilson acknowledges that. In fact, they cite a treatise, what constitutes obstructing or resisting an officer. And if you look at that particular treatise, I mean, it goes on for multiple pages of various conduct that would entail obstructing. So here, it's not simply about the words. It's not simply about the fact that Mr. Decastro was annoying. It's not simply about the fact that Mr. Castro was saying things like calling the officer doggy and whatnot. It's not about that. It's the totality of the circumstance which prohibited the officer from being able to safely and adequately conduct the traffic stop. And that's,
Well, he immediately released her.
He did.
Also. I mean, he gets out of the car. I mean, it appears to me he was gonna release her regardless, because it was so fast. He said, you're free to go, and then he went to take care of the other issue.
Now, I want to say something, everybody, that when a judge in an appellate court is looking over a case, it's common for the judge to view the evidence in the light most favorable to the winner in the trial court, right? So the winner in the trial court in this case was the state. But this judge is asking a lot of very pertinent questions to Chile's defense, which is making me think that she's viewing it in a light, she's trying to view it in the light most favorable to the state. But the evidence doesn't support the conviction at all, and she's having a really hard time trying to do it. So let's keep going.
Yeah, well, I mean, what we have in this particular one is he went and did the records check, and then he mentioned too, she was surprised or even confused by the fact that she had an issue with her registration. Exactly. Now, again, I don't want it's speculating to assume what happened there, but certainly those are the facts that came out at trial. And so ultimately, whether he was going to take it or not, he may have taken her. Obviously, he pulled her over because the system, as he testified, said that there was an issue with her license. But because of the fact that this all went on, perhaps the obstructing was that he didn't feel comfortable to write. It wasn't worth writing this ticket. She already was informed of it so that he could deal with this other situation of this individual who's clearly obstructing with his ability to get to the very end of his investigation, whether he was going to release her or whether he was going to write the ticket. But the problem is the impediment is the individual who's continuing to yell and stand a number of
You
feet
can
away.
never do that.
All right. So I just want to point out, I mean, I know this is the defense attorney's job, but I just want to point out how ridiculous this is. I mean, he says, first off, he starts his argument by saying, well, physical action could be interpreted as many different things, Your Honor, you know, what we do with our bodies. And then he claims that the only physical action in that argument just there was Chile standing a few feet away. And then he says that, you know, he was yelling stuff. He was talking. Who cares? You're allowed to yell at a cop. You're allowed to talk nonsense to a cop. You're allowed to say anything you want to a cop. I mean, anything you want, as long as it's not a threat. And that's what the defense attorney brought up. And it's really telling that the state's attorney is not mentioning the fighting words aspect of it. Because Chile's attorney had no problem mentioning the other requirement. That was fighting words. But of course, this attorney is like, you know, fighting words, it don't want to mention it because it doesn't help his argument. It only hurts it. That's why.
Then if all the officer had to do was say, because I had to go deal with this, I couldn't write the citation, right?
I think it's time, place, and manner specific, though. In this particular case, when you watch the video, I think he is that much of a problem that this officer ended up, you know, talking to him more.
But what's the obstruction? It's not the words and it's not the filming. I mean, the officer, to his credit, he said right away, you can film, you just need to back up, you know? And I understand he didn't want him talking to the driver, but it didn't appear to me as though after he was instructed, don't talk to my driver, he didn't talk to her anymore. Is that accurate?
That is accurate, yes.
Right?
And
It's-
I don't want to testify to that.
Right, and then he backed up. I mean, I understand the officer didn't think it was enough, and so, I mean, is it just that he didn't back up far enough for the officer? That was the obstruction?
He didn't back up far enough in addition to the manner in which he was acting. So had there been a conversation saying, officer, and again, everything is so fact specific, right? But the fact that Decastro is immediately yelling, arguing with the officer about the amount of backing up that needs to be done, that's what the issue is. It isn't about the space in itself or the distance in itself. It's a combination of factors of everything involved. Now, Mr. Oram says that depending on who the officer was and where it was at night, I believe where it was could play into it, but I think it's an unfair statement to assume that some officer, simply by virtue of being a female, would somehow be in an incredibly worse position, and that Mr. Decastro, for instance, could treat her differently or would need to treat her differently than the officer that we have involved here. I think
Well, if it was in Ely on the side of the road at 3 a.m. on that road between
for any
Reno
individual,
and Vegas,
for any individual, I would agree. For any
I
individual.
agree.
I'm just saying that it seems incredibly sexist to say that somehow a female officer would be unable to defend herself on that Ely road, but somehow a male officer would be automatically good to deal with the Decastros of the world who want to interfere with the investigation. That's what I'm simply saying. That I at least wholeheartedly disagree with the characterization there in terms of the time, place, and manner. But I agree, an isolated road could be a factor. But they're all just factors. Now, this case has its own facts. There will be other cases that come through the line, but I'm just arguing that pursuant to these particular facts, he was convicted of obstructing. And Mr. Arm doesn't address at all that second issue, which has to do with the resisting portion of things. Now, I think the case law is
That
clear.
Lisenby case, I mean, so even if, let's say, even if I agree that there, this wasn't obstruction, it was unlawful to detain him, that Lisenby case seems to indicate you still can't resist.
And that would be our argument. He hasn't addressed it, I'm sure he will on this reply, but that's the last of my argument. Thank you.
And I'll address that. First of all, I didn't mean in any way, Judge, you could take the biggest male officer. I meant just giving the scenario. It could be 1 in the morning, 3 in the morning, female, male. I didn't mean it that way. I just meant the visual of how it's different there. What I just heard was sort of interesting. Mr. Chen just said, I didn't argue the 21-foot rule because it didn't, it's not applicable. They sure did it trial, didn't they? That's what they argued. Even the prosecutor argued it. So Mr. Chen is only retreating from it because it's not a rule and it makes no sense. It's something.
Sorry about this, guys. I don't know what exactly is going on with the
Being used as
stream here.
in self-defense type issue.
Right, but if the officer would have said that, I'm not sure that would have been unreasonable.
I
I really want you to be about 21
Yes.
feet back,
Yes.
give me some space, and,
Right,
don't go past this white line. I mean, there were markers in the parking lot.
right. And if he had grabbed his citation started and Mr. Castro got, well, you're not gonna do that. It's obstruction. This is an obstruction. And the 10 feet, I agree. Is it 10 if you're only 9.5 feet? Is it? No, I don't think that's the point. The point they're trying to make is that our statute tells us we can film police officers. It doesn't say 10 feet, 21 feet, it just says filming them. When he was told to back up, he did. And the state is now saying, yes, we all agree with that. We're quibbling over words. I'm only quibbling over words because they kept saying at trial he wouldn't back up, which is not quibbling with words, it's inaccurate.
That's true. I mean, the officer did testify in direct examination repeatedly that he didn't back up.
Yes,
But on cross indicated, well, he did back up, he just didn't back up.
substantial.
Yeah, he may have backed up inches, he didn't substantially back up.
Now, with regard to what are the intentions, I keep hearing, what are these intentions? He didn't know what the intentions are. And then that's why I put up, because I think there was testimony that I don't know who this guy is connected to. You don't know who this person is. Well, the officers employed didn't know who these people were. The people filming, they didn't know. They didn't know it was an off-duty firefighter. They probably had done something different if they knew who they were dealing with. But they didn't know, and so the same arguments could be made. Oh, they're within 10 feet, officer safety. Maybe those are all gang members, and they're the same gang as George Floyd. It's his brother, so I won't be sexist. It's his sister who's gonna pull out a gun, or some other person, male, female, gonna pull out a gun and shoot it. So we are doing this for officer safety. No, it isn't. And the courts, you can look at George Floyd and realize the courts in a big case in the United States said, these people have a right to do that. And the question I really ask, I think is important. There was no abuse. The officer wasn't doing anything abusive to the driver. It's clear as day. Okay? What if he was? And he caught it on film. And now it's hitting CNN and Fox and all of this stuff. Then they say, oh yeah, we caught him. And 10 years from now, the Third Circuit's going to be quoting what he did. But he didn't catch them. So is that the standard? Can we film police officers? But if they're not doing anything wrong and I'm using obnoxious language, then I can be arrested? Is that what the standard? It isn't, Judge. The application.
You're allowed to be annoying.
Yeah.
You're allowed to be annoying.
Yes. The judge says you're allowed to be annoying.
And I realize we as lawyers appear in front of judges all the time. We appear in front of juries. We're trying not to, want to be obnoxious. It won't help your case. It won't help that. But I recognize this is some cornerstone. It's a foundation of our nation. The resisting. Did you notice the officer said, oh, when this resisting is happening, my body cam all of a sudden doesn't go out. He testified he never resisted. And you can see it on him. He tells him, don't do it. The officer really grabs him hard. And then he's like, okay, I'm walking. You even see him with his camera. I'm walking back to your car. There's no resisting. He's trying to tell him, you're being unconstitutional. He does say it. You can't do this to me. Call your supervisor. But they get him in handcuffs, and there he sits. By the way, the state didn't ask for him to sit there. Agnes Lexus asked for a suspended sentence, and Judge Zimmerman decided to give him the maximum. He's been in there 4.5 months for this, and I kind of wonder.
To that characterization, it's not a maximum. It's 3 months on each count consecutively.
Right, yeah.
Oh, you're right. Okay, you're right. I said.
That's who cares? Who cares? Oh, it's a mischaracterization. It's ridiculous that they sentenced him. He's been sitting there for 4.5 months. God bless his heart.
For whatever reason, I guess misdemeanor 6 months, 6 months. Yeah, so she gives him, but the state didn't ask for that. They asked for concurrent 90 days suspended. It goes to show what really happened. There were so many different errors, and I can tell the court has a good handle of this. Judge, there is no resisting. It was an unconstitutional arrest. The man should receive the benefit. I mean, we have a beyond reasonable doubt standard. We can look at Wilson. I now hear the state really struggling. They almost sound like me in a bad murder case where they're saying, well, what is physical conduct or contact? Because that's what Wilson said. And they're struggling with it because they don't even, because there's no physical contact. Backing up and filming and then pulling out a second camera, it's not physical conduct. There's nothing physical. He doesn't do anything physical. The officer just lost control. And he was irritated. Maybe we understand. It's not.
Yeah, you can understand. Yeah. I can understand.
Okay,
and
yeah.
It kind of comes out of nowhere.
It's out of nowhere. It's who wants to be called names? But that's what the courts are all saying. You've got to ensure this. Our citizens have a right to do this. And it also keeps our police, these auditors do help in some way because sometimes the approved police are doing, if there was an auditor on what he did, and that one was like, oh, he was saying these things. He wasn't. If I'm not a witness to it, no, he isn't. And the video shows that if somebody was filming it, he wasn't doing anything wrong. So some false allegation by some crazy lady, okay, it helps them sometimes. And also sometimes it catches bad police officers. Here, what we have is a situation where you had a right to do it. And so for those reasons, I ask that you grant the appeal and reverse this man's conviction.
Anything else from the state?
I would only briefly say that in the Floyd case, no one was arrested. That's what the distinction is there. So people were allowed to film the encounter, and obviously other things happened from that case. But the issue is not that they were filming, that no one was arrested there. And the case law makes it clear in Listen and other ones, if there's a probability of substantial harm or death, then individuals can actually interfere and it wouldn't be obstructed. So the case law, I just want to point out that distinction, but otherwise I have nothing else.
Okay, so this time the court's going to grant the appeal and reverse the convictions based on its First Amendment protected conduct. And Mr. Orm, you can prepare the order.
Yes, ma'am. Thank you very much, Joe.
That's what I'm talking about, everybody. All right.
He needs to be released from custody, so.
He'll be released.
Yeah, that's what I'm talking about right there. Let that stand tall now. He was wronged by the state. He was wronged by the government. 4.5 months in a jail cell in Nevada, in the biggest county in Nevada. They ruined this guy's life for 4.5 months. This is ridiculous, people. And Judge Zimmerman did it. The prosecuting attorney did it. The prosecuting attorney in this appeals hearing did it. The judge did it. That nonsensical tyrant cop. He did it to this man, to Chile Decastro. You see him right there. And now the judge just overturned his decision. That's a victory for us, but I'm going to tell you, he lost. He won this court case eventually, but he lost 4.5 months of his life. And he had to hang around people who would have influenced him. And these influences will last for a lifetime. And the treatment that he got in the prison, it will last for a lifetime. But I'm going to tell you, we're going to keep watching. We're going to see if we get any victory from or any showing of happiness from Mr. Decastro. He looks pretty happy right now. Let's keep going. Let's watch it.
Ready, sir?
No. That is an arrestable offense. I'm sorry.
Did you all see that? Let's watch that again. He just won. He's released from custody. The judge just ordered him released from custody. And because he's an inmate, this clown tries to say he can't talk to somebody in the courtroom. He's not an inmate anymore. That's not against the law. Let's keep watching. Let's watch that again.
Other things happen from that case, but the issue is one point at that distinction, but otherwise.
Well,
No.
thank you.
Thank you.
Ready, sir? No. That is an arrestable offense. I'm sorry.
They're so salty that they just lost. They're so salty and they just lost that they're gonna threaten to arrest him again, even though he's just been released from custody. This is hilarious, people. You can't make this stuff up. But we just look, the people won, Chile won in court. He is gonna be freed. That cop is butthurt and he's angry and he's yelling and he's saying that's against the law, but he knows it's not against the law. And if he tried to arrest him for it just there, it would have gotten overturned just like this one, except it probably would have just gotten overturned right on the spot, So, yeah, what an asshat. I mean, what an idiot. He's mad because he just lost. He's a part of a system that ruins people's lives, that steals people's money, that beats people into compliance, and he still thinks he's one of the good guys. But this court case that he just witnessed proved him totally wrong, everybody, right? So, with that being said, guys, I was going to do a little bit of a panel with people, but I am not going to do that. I've been on the live stream for an hour and a half. I've had to ask my family to be quiet for me to do this. So I'm glad we could watch this together, everybody. I'm glad that Chile is now free. I hope that we all kind of give him some space, let him do his thing, let him enjoy his freedom. He will talk when he's ready to. He will reach out to people when he's ready to. And, I think that the last thing that he needs is all the stress of everybody blowing his phone up into smithereens the second he gets out. So with that being said, everybody, I mean, this is a huge victory. It's a massive victory. Go and don't blow his phone up. Blow his YouTube channel up. Everybody leave this live stream. Go over to the Delete Laws channel. Watch his newest video. Say Craig Henry sent you and say congratulations for winning this case. That is a massive victory. I bet all the bootlickers are just going to be so quiet after this one, don't you think? After their own court said that they were wrong. Incredible. He is going to get so much bread. He's going to get so much money. This guy Ponzi, he's mad too. He will be back in there. No worries. I don't know, Ponzi. I don't know why you're salty, brother. I don't know why you're salty because he was wronged and he's going to get paid. I don't even know if he's going to keep going out and doing audits. He might just do activism behind a computer now. So, but with that being said, everybody, we'll take care. I hope that everybody takes care. I certainly will. I'm just absolutely ecstatic about this. So take care, everybody. We'll see you. Bye.